All rise. The Court of Appeals Division 1 is now in session.
Morning, please be seated. We're here for oral argument in case number CV23-0045. That's our case number. Dawson v. Dawson. Counsel, please understand that we're recording and live streaming the argument, so please identify yourselves and your client at the beginning of your argument. Each side will have 20 minutes, but you're not obligated to use all that time. Appellant's counsel, please watch the clock and reserve as much time as you desire for rebuttal. Please also keep in mind we've read the briefs, we've conferenced the case, and also studied the record. Counsel for appellant, you may proceed.
Good morning. May it please the court, I am representing Mr. Dawson, the appellant in this matter, Sandra Slayton. And this is a case where it centers around the community business, hospitality construction business, who had only one customer, Goodnight Inns. We note, and I think it's significant, that hospitality construction's income for 2019 through 10 months into 2022 had a progressive decline. I mean, that's really undisputed in the record. It was, income was $443,492 in 2019 out of a revenue of $3,714,000 and change. And in 22, it dipped down, in 20, it dipped down to $580,337 out of $3,782,285 in revenue. In 2021, it was only $121,057 of income out of a reduced revenue of $2,630,449 in revenue. And 10 months into 2022, at the time of trial, 10 months in, it was only at a revenue of $1,935,000 and over $300,000.
So, counsel, these are the kinds of evaluations of a business that superior courts make, I don't say every day, but they commonly make, and we entrust them to make these. So it might have been reasonable here to adopt a one-year valuation period. It might be reasonable, you're arguing it's not, to have a 3-year period. But aren't these the kinds of distinctions the superior court has the discretion and fairly broad discretion to determine which model is more accurate?
Well, I mean, it depends on the record. And it depends on the decree, and it depends on the court's reasoning. So, I mean, there is a legitimate abuse of discretion as a matter of law that is sometimes reversed up here in the Court of Appeals, and the court did that in Meister, and the court did that in Sample.
Well, you said it depends on the decree, so why don't we take in two different parts in our discussion today. Okay. First, the question of substantively whether it's an abuse of discretion to have a 1 versus a 3-year period, or I guess a 3 versus a 1-year period, your argument. And then secondly, the character of the decree and whether it did that sufficiently. Can you speak to the first one? Why are the facts such that it would be just an abuse of discretion to basically do what Wife's expert suggested, that the 3 years gives you more data, there's more information, it's a longer, smoother period? Sometimes that's the right answer. Why would that not only be wrong, but an abuse of discretion here?
Because in looking at the record, and I just want to say that if we were only dealing with the issue, the one issue of is there sufficient evidence in the record, if that was the only thing that we were dealing with here, it would be a much harder case for appellant, I believe, to convince the court. It might still be, but the point is, we're dealing with a massive deficiency in the record on we do not believe there's sufficiency in the record to arbitrarily pick the 3 years. Let me read to you, and we cited this in our brief, Your Honor. Kotzen, so we know there was this extreme downward trend from 21 to 22, from 19 to 22. We also know, just as in Meister, Goodnight Inns was hospitality's only customer. 4 hotels were sold. Okay, there's no question but that the income dipped way down. And when Kotzen was asked the question, and he was the same expert in both cases, by the way, Meister and this case, when he admitted at trial that he did not believe that the drop of the income was manufactured for 2021. The question was specifically asked to him, would you have any concern about using 2021 if that was the year of filing for the divorce? His answer was specifically, well, I don't think it's based on the filing of the divorce. And you can find that, Your Honors, at page 236 of the transcript. And so it was fairly arbitrary. But on top, I mean, because Kotzen just based it on like one sentence of the website that basically said, of Goodnight Inn, which basically said, we're looking to expand.
I just want to share my internal dialogue, because you only have 14 minutes, but it's kind of confusing to me, because it seems like the point of whether 1 or 3 years is within the ambit of discretion is whether it accurately sort of predicts the future performance of the business in some sense.
We don't think it does.
I get it. Let me ask the question. I apologize, counsel.
Sorry.
So I guess I'm not hearing anything about why the 1 is more predictive than the 3. The 1 is lower and it came later, but why is it so unpredictive that it's an abuse of discretion? I haven't heard that yet.
Well, I think the question, and then I'll get on to the other things that you were concerned about. I think the fact that you're asking that question, and we're up, and you've read the record, and we've analyzed all of this, and you're still asking that question, as am I. There has to be an analysis. There has to be a justification for why Kotzen chose to ignore this extreme dip with the only customer, with the undisputed dip that he said was not manufactured. And so that's precisely my issue. If the court doesn't go into and then we go into my second issue, which is that the court did not engage in a sufficient analysis. Yes, the court has discretion, but there has to be some reasoning, and I just don't think it's there.
Well, what's the level if I understand the record correctly, your client did not request findings of fact and conclusions of law? Is that
No,
right?
that's correct.
Neither party? That's
correct, but in Meister, that was also the situation, and yet we know from your case in Meister, which relies on sample, that there has to be it has to meet I think they put it as the test of fairness, the ability to show that this is an equitable result on appeal.
So, counsel, a lot of times in cases like this, Superior Court will say, can you give me draft findings of fact and conclusions of law? And 9 times out of 10, the Superior Court judge essentially rubber stamps them and pastes them out of a Word file, occasionally deviating slightly from them. So is your thing really that it would be so much better if Judge McCoy had pasted the elements of Kotzen's report instead of saying, I adopt the analysis and you agree she adopted the analysis? Why is that meaningfully different, counsel?
I think what happened here was a rubber stamp of Kotzen's report.
Okay.
So, and that's wrong. It doesn't, you can't just say, I adopt Kotzen's report and then take, like his report itself was conclusory, just as in Meister. He did the same thing there. So, but let's look at the decree. Let's look at the decree itself, because the other concern, and like I said at the beginning, if we were just dealing with the issue is there sufficiency in the record? I mean, okay, but the court didn't, the decree literally provides no numbers. We don't have a value.
But hold it, aren't the numbers Kotzen's numbers? Do we really not know the numbers? Is that fair?
It is fair, because the cases say, Meister says, Sample says, the other cases all say that you have to be able to glean from a judgment what is going on.
But you said at page 10 of your reply brief, there's no substantial evidence to support the trial court's decision to adopt wife's expert's opinion and report. I did the math before this, and one side got $3.182 million, one side got $3.192 million, and that's straight out of Kotzen's report. So if I know that by reference, why is it not the same as if she stated it?
I think a judgment has to actually state what you're relying on, and you have to be able to pick up a judgment and know what it says. You can't just you can't defer, almost like a De Pasquale situation, to some other numbers in the record. The other thing is, not only was the judgment totally lacking in the numbers, but the other assets weren't even valued. So to the point where we can't even glean, I mean, when I say we, I mean the reader can't really glean. Your Honor, did you want to say something?
Well, the other pieces you're talking about were assumed within the overall valuation. I mean, by looking at the report, we can tell that they were there.
We think so, but then the judge said in the decree the airplane was used. I'm not ready to say this was totally a business asset, because the airplane was also used for personal, and we don't really know what the court meant by that. I mean,
well,
so
going back to the fact that there was no request for specific findings of fact and conclusions of law, and going back to Meister, we specifically said that all the court had to do was provide enough analysis, however it's labeled, for us to determine whether or not we find an abuse of discretion. Again, when mathematically we can go back and look at the report, look at the decree, and see that the 3.182 versus 3.192, that there was an argument between the parties as to whether it should be 1 or 2 years. The court adopted 3 years. Isn't that enough? I don't see that any case out there says that's not enough. Even
well, I'm sorry.
No, that's okay.
Well, I think that when you have the analogy and the facts are so easily analogized between Meister and this situation, Hospitality Inn was his only client. There was an extreme decline in the 2001 and going into the 2002 year. It wasn't an equitable result. There wasn't, when you go back to Kotzen's report, as in Meister, you don't get a sufficient reason or justification for why these other years should be averaged, because clearly the decline was like going way down, and he wasn't able to, it was all speculative. He just said, well, they said on the website that they wanted to expand. So that's basically where I'm coming from, plus the fact that there were no values at all in the decree. I think it is lacking. I think the judge did lack an analysis. I don't think Kotzen's report was sufficient. I think when you trace it all the way back there, so you've got it on 3 different levels here. I'm going to save the rest of my time for reply.
There's a 10-second question here.
Sure.
Because you're talking about the vehicles. I mean, the decree does say that it awards all vehicles to husband and wife that are currently in their possession. Doesn't that include the trucks and the Cessna?
The truck, but then that's on the one hand. But on the other hand, the trucks and the Cessna are part of the business.
I agree.
It's very...
It seems to me it was allocated twice, not 0 times. I guess that's my issue.
I've got a lot of issues because I don't think this is an adequately enforceable.
So you think under the decree it's not clear whether husband was awarded the trucks and the plane?
I don't. And I don't know what values they were given. It's not there, Your Honor. Thank you.
I understand your position on that, counsel.
Thank you.
May it please the court?
Hey, counsel, let's just jump in. Is this a best practice decree? Is this the way you should do a decree? Is it it's incorporating by reference an expert report like that. Could you speak to counsel's principal thrust of her position? I think it's a very thoughtful position. Let's talk about that.
Yes, just quickly, my name is Amy Hoffman, and I represent Cheryl Dawson. Your Honor, could you state your question again? I'm so sorry. I was thinking I needed to announce.
I'm really eager to hear what you have to say about opposing counsel's argument that just rote incorporation of an expert report. Let's assume for the sake of discussion it's a great expert report and not what counsel says it is. Is that okay to do? Is it okay what Judge McCoy did here?
Absolutely okay. And here's why. What the standard is under Meister, under Bender, under this court's case law going back decades is there reasonable evidence in the record from which we can sustain this decree? Can we find that it was equitable? And here, as Judge Brown pointed out, there weren't any requests for findings of fact or conclusions of law. And in Bender, this court said, then the court assumes that the trial court found every controverted fact necessary to sustain the judgment. And if there's reasonable evidence to support such finding, we must sustain the judgment. In my, sorry, go ahead.
If I could, but the question was, wouldn't it be a better practice to have included a little more than just the citation to the report? In other words, the better practice we've also recommended.
I agree that the decree would have been a little better if the judge had used some numbers. I adopt Kotzon's report that the fair value of this business of hospitality construction is $2.8 million or whatever that specific number was. But it isn't fatal to this court's upholding the decree that it did not, because you can ascertain what that business was from the record.
I think that's the point that I wanted to get. I hope that didn't step on Judge Jacobs' question.
No, it's interesting. So is it your position, and it's hard because you're counsel, you don't want to back up away from the decree or leave an airspace, well, maybe this isn't okay, but I mean, would it be okay if the entire asset in one of these cases is the totality of the marital community, just have a one-sentence ruling that says, I adopt the expert report, drop the mic, go home? Would that be okay?
I think it depends on the record, Your Honor.
So if it's a really good expert report, then yes?
Yes, I do. I think that's fine, because the standard is, can we ascertain the equitableness of the division of property from the record? And if you have a really good expert report, then yes, the court can.
And then result if they had requested the findings of fact and conclusions of law?
If I understood your question.
In other words, would that result in some, could this decree stand under if a request for findings of fact had been made? It's a hypothetical, I admit.
Yeah, I'm thinking about it. I think
more problematic, at least, if that had been made?
I think probably more problematic if that had been made, because that is a separate standard, but it does not apply here, obviously, since no request was made. But yeah, in that case, the parties are asking for a detailed breakdown instead of just an incorporation of an expert report. But since here it wasn't made, different presumptions and assumptions apply, and that's when Bender kicks in and says, does the court have reasonable evidence to sustain the court's ruling?
Well, just to illustrate the point I take from Judge Goss's question, I mean, which valuation was it? I mean, there's a fair market value and there's a fair value. I mean, which was it?
Agreed. Now, Kotzon explained in his testimony that you use the fair value when there's no sale pending, because you use the fair market value if there's a sale pending, so then you assign certain discounts, for example, the brokerage fee. And I think that the court could look at the record and say the court applied the fair value as there was absolutely no evidence that a sale was pending.
Does it have to be a pending sale, or is it just the type of a business that could be sold on the open market? Why it almost seems like you're phrasing that a bit too narrow in my mind.
Okay, I think that's a fair point. Yeah, no sale.
Say you have a XYZ business, a car dealership. I don't know. I mean, maybe that's a little bit easier to contemplate a sale of a car dealership than a one-person shop is what we have here. That's very unique, a very unique situation. Would you agree on that?
Oh, absolutely, yes. If you have a Toyota dealership, I think you could probably come up with a market value of that very easily. This is a one-man shop owned by husband. He's the sole employee. So Kotzon even evaluated that in his report and said this is hard to find a comparable business to compare it to.
So does it matter? Did Kotzon need to say, or did the court need to make a finding specifically to say, I find the fair value I'm relying on fair value, not fair market value, because I didn't see the court make that. Did the court need to?
I don't think the court needed to, because either under the fair value or fair market value, the court could still derive from the record that the numbers reached an equitable result based on Kotzon's report and the valuation of personal property.
Well, actually, they're $400,000 apart, so the numbers I gave, 3.182 and 3.192, depend on selecting the lower of the two. The higher would actually be a plus 400,000, but I infer without exactly knowing the court didn't do that, because then it might not be equitable to award one side $400,000 more. So I'm inferring from the lack of a finding that it was the lower amount selected.
I agree with your inference, Your Honor. I think that that's what the court did, and I think that this court is allowed to make inferences and look at the record and look at the expert report and run the numbers and say, was this an overall equitable result? And here it was. Husband got the business. If you look at Kotzon's report, which is clear Your Honors have done, the Cessna was part of it. It's part of the business value. The trucks are part of the business value. You can't say, who knows? Who has the Ford F-250? We know. It's part of the business.
Well, counsel has another issue separate and apart from the character of the decree. And actually, the decree does give some analysis of its own outside of Kotzon's report on the 3 versus the 1 year that sort of gives some thoughts about it. Can you please speak to counsel's concern that she thinks it's 1 year is an abuse of discretion? Can you explain why 3 years is not an abuse of discretion, independent from us talking about the quality and character of the decree?
Yes, I'd like to. And I'd like to make an initial factual point that Kotzon's wife's expert's report said October 31st, 2021 is the date of valuation. Husband's expert did not dispute that. So as far as we're talking about 2022, that's not part of this discussion. So talking about 2021 versus 2019, 2020, and 2021, it was well within the court's discretion to adopt a 3-year average. And Kotzon explained, and I assume this is what the court was looking at, that for an income approach you need a history. An income approach is not a snapshot. An income approach looks at, okay, what happened in these years so that I can actually predict what's going to happen going forward. And you look at the number of years, risk, and then you apply a capitalization rate to adjust for that risk. Here, the court adopted the 3-year likely because of Kotzon's explanation at that point, and that Kotzon believed that that was equitable. It was what the court had a basis in the record to do so, and therefore I don't believe it was an abuse of discretion.
So this is the thing, and I'm giving, I think my face probably has like an expression that is showing that I'm not understanding something, so I apologize to both of you because I'm asking this question. I think it's kind of an obtuse question, but opposing counsel has said 1 year is not predictive because it went down. You said 3 years is predictive because Kotzon said so. Can someone go behind the logic and explain to me like why? Not Kotzon said it, which I agree is part of the record, and maybe that's enough to not abuse your discretion as a judge. Well, an expert said it, he's thoughtful, he's got a methodology, that's great. But why? Why is it true that 3 years is more predictive than 1? I've not heard why 1 is really more predictive than 3, or why 3 is more predictive than 1. That's the thing I'm concerned about with this issue.
Maybe I can answer it this way, Your Honor. Judges have tremendous discretion to assign weight to witness credibility, and here they can do that with experts. So this judge heard from Mr. Kotzon, heard from Mr. Pankow, heard from husband, and heard facts that weren't necessarily favorable to husband, such as they had been withholding, this was a contested fact, but the court found it, perhaps withholding subpoena responses because Goodnight Inns was run, or the subpoena responses were given by husband's girlfriend. Kotzon did not think they had a fulsome 2021 response. Husband withheld the flight logs in discovery that wife wanted to show, no, this isn't true that 2021 business went down. So the trial court had all of this before it, all of these facts, and has the absolute discretion to make these witness credibility determinations and could use that to say, I don't think 2021 is appropriate for the year to value this business.
So we've seen this before in the family court where the entrepreneur partner in the marital relationship has an asset and then things occur that make it look a year or two before. Now, opposing counsel's made her argument, which has grounding in the record. Well, that 1 year it was really legitimately worse. And you're saying it's a mixed question and you could go either way on it and it's within the court's discretion to read that as, playing a little bit of games with the last year. That's what you're saying.
That's exactly what I'm saying. Yes, I think it's a witness credibility issue, and that supports that it wasn't an abuse of discretion because the court has that discretion.
So if I can just make it clear, just as we're walking through this, one, we had expert witness testimony on the valuation. So there was evidence in the record to value it, that both parties submitted and both parties felt the evidence they submitted was enough to get them there. Second, we have a clear valuation date that was never disputed. Third, we have an agreement on the way to value it, the income method. Neither party said that's the wrong method, did they?
No.
So I got, through 4, the only issue was 3 versus 1, and they both said why they thought 3 versus 1 was correct. And the court then at that point had 4 things that were agreed to, and 1 issue really in dispute, 3 versus 1, and based on the evidence the parties submitted, made a decision. Is that a fair assessment?
I think that's a very fair
And that's
assessment.
what an abuse of discretion is about. Unless there's just no evidence, we give it to the court.
That's right. That's right. That's what the precedent says, and that's why we give courts discretion so that they can make these evaluations.
Could you help me understand the sale of the 4 hotels, right? Goodnight decided to sell 4 hotels, which I think husband's position is that was a very material impact on the value of the business. How did Kotzen deal with that or did he address that in his expert report? And can you explain that for me? Or what did the court do to bake that into its decree?
Yes, Mr. Kotzen did address that by those sales. So husband basically generates revenue when the hotels are sold, but then that's not a continuing source of revenue. He's in construction, so that's gone. Kotzen...
He gets revenue, why? Because he's a part owner?
Fixing them up as a construction person.
To get them ready to sell?
Yes,
Okay.
yes, that's my understanding. So that revenue source, of course, would dry up if he doesn't have access to the hotel anymore. Kotzen included those numbers in his report, but he did his own industry research, looked at Goodnight Inn, looked at the tenor of hotels in general after COVID, and concluded this is actually a growing business. And Mr. Penkow actually did interview the owners of Goodnight Inn, found that they had acquired 2 or 3 hotels, and Mr. Penkow did not opine as to whether they were planning to acquire more, but it was within the court's discretion to infer that this is a growing business, not a shrinking business.
Can I follow up on a point that I should have asked about earlier? But as we look at the report, there are 2, high and a low valuation, and obviously a range in between. From the math, it appears the judge used the lower number. Would that also support that the court may have at least, and we can certainly, the evidence would support that the court took into account the lower income in that final year? Because it didn't go with the highest possible number, it did go with the lower number from the report.
If I understand Your Honor's question, I think...
If I didn't ask it well, please let me know. I apologize.
It could be me. Are you asking about the 2-year versus the 3-year?
Yeah.
Okay.
Going back to the valuation, which is in making the decision to accept the 3-year and the overall valuation, and whether the court took into effect or into consideration the very low income in the 1 year. That the court didn't adopt the highest possible valuation, but it adopted the lowest possible. It didn't even go in the middle. It appears to have adopted the lower end. Wouldn't that also support that the court took a look at all of it and made a decision?
Yes, absolutely. And one of the points that husband made in his brief is, well, 2021 couldn't have been invalid because Kotzen used it. But Kotzen made a decision to say, I'm going to incorporate 2021 because if you don't, you get a much higher value for hospitality construction. And that didn't seem fair to Mr. Kotzen. It didn't seem like an accurate income analysis. So the court and Mr. Kotzen also incorporated 2021 in those numbers. So that's included in the value. And we actually argued that had we gotten all of the subpoena responses and the information we needed, 2021 could have been higher, resulting in a higher value. But this is what the court came up with as fair.
It could have been lower. We'll never know.
Well, it could have been, perhaps. I want to talk about Meister just for a second, and only because it was heavily debated in the briefs. There's a couple of points in Meister that I thought were important. It's a distinguishable case, and I'm just going to read a very short clip. This court said in Meister, neither the record nor the court's ruling support the trial court's finding. And I think that neither the record is really the key here. We have a very good, solid record here showing why this court can and should uphold the court's ruling. And in the Meister footnote 4, the court said, specific analysis addressing the test of equitableness may not always be required. For example, if reasonable evidence is readily apparent from the record that the selected date evaluation and resulting value are equitable, then the appellate court can meet its obligation. And I think that the Meister case actually supports wife's position. If the court has no further questions, then I will have a seat.
Okay.
Thank you.
Counsel.
Well, first of all, this whole thing about withholding subpoena responses, that wasn't part of the court's analysis. The court didn't even give attorney's fees in this case, and they were requested. We're all inferring here. In fact, if we really look at, the court just picked this arbitrary number, $300,000 of equalization, and we could all sit here and pontificate what the court was relying on. Was she relying on, as Your Honor, Judge Jacobs said, the lower value, and Judge Brown and Judge Gass, I guess you all think she was relying on the lower value, but she doesn't say that. And where did this $300,000 come from? Again, we are really left with nothing but inferences. And I think if it was a really solid record, you might be able to say, I mean, when they say, when the Meister court said, the record readily available in the record, I mean, I think that means readily available. And here we are, the whole argument today dealt with, well, I think this is what the judge meant. Well, couldn't the judge have meant that? And that is, to me, by definition, a deficient decree.
So let me ask you a question, just try to give you a chance to unpack this on one of your major arguments, counsel.
Yes.
So it's our law, and this is Stevenson. On appeal, we must assume the trial court found every fact. Must assume, we're required, must assume the trial court found every fact necessary to support its judgment. So why are there insufficient facts within Kotson's report to justify a 3 versus a 1 year analysis? Please explain.
He doesn't say. And you had to sit here today and ask the question. We all did. Was he talking about fair value? Was he talking about fair market value? I mean, there's a $400,000 gap there. And the court decides, without saying why, $300,000 as an equalization to wife. And what you have when you read wife's brief, it are a lot of charts, right, and a lot of numbers, but they were all done by counsel because we can't glean from the record what he meant. We can get him back up on the stand and ask him.
But counsel, I don't think it's fair to say we can't. I mean, there are two values. One is $2.399 million, which is fair market value. One is $2.823 million fair value. So when the court adopts the report, it must be adopting one of those two and not some other thing. Now, the higher number would have been your client getting $400,000 more, which presumably would have required a higher compensation payment to wife. So if we assume, as we must assume, that the court did this in a way to justify its judgment, which was claiming to be equitable, we must assume the court took the lower value because then the parties got basically exactly the same thing. Like, why is that wrong, counsel?
Because you mentioned a word that is at the heart of Meister and is at the heart of Sample. And those two things that we just discussed, the necessity to assume, as you must, if you can, versus it must stand the test of reviewability and equitability on appeal under Meister. And our position is here that just as in Meister, with the undisputable, just the income went straight down without any justifiable really reason in Kotzen's report saying that it's going to go up again. It's speculative. And I think the court missed, just as in Meister, the reality of this one customer for Mr. Dawson's business, just like the asphalt contract. I mean, it's all there. Or it all isn't there. The record wasn't sufficient. It didn't lead to an equitable result.
I want to look at Meister, because what we said in Meister was the court must, and the Superior Court must, provide enough analysis, however labeled, to allow an appellate court to fulfill its obligation to decide whether the valuation date and resulting property distribution withstand the test of equity and fairness. We're not here to decide every single little thing the court did. But at the end, did this result in a fair and equitable? And when we look at this, and we can say the court used the lower amount, which actually, in order to your client's benefit under the report that the court seemed to have used, that the valuation date really isn't in dispute. Nobody said that the report used the wrong date. How is it that we can't fulfill our obligation of looking at the test of equitable and fairness? Because I think that's the question you need to answer. Why can't we do our job?
I think if you look at the record, you have the same situation that you had in Meister. You have Mr. Kotzen. In both cases, you have a dip that is so extreme, so dramatic, with a one customer situation, and you don't have a rationale for why the average is fair versus just taking what it's worth now. I think it's not equitable. I think the record doesn't support it. And not only that, but when you take that with the insufficient analysis of the judge and the absence of almost no numbers in the decree, we are all guessing. And I don't think decrees should be a document that we have to guess on. We're going to be guessing forever.
Counsel, thank you both for your arguments this morning. The court will take this matter under advisement and issue a decision in due course. The court stands in recess for a few minutes to prepare for the next argument.